guys, my name is Adam Gravel, nobodygravel.com. I am bringing you something live today. I'm bringing you something today that nobody asked about, nobody cares about, nobody seems to care about, and quite possibly nobody's going to want to watch me talk about this. But I've been following the Trump Mar-a-Lago FBI raid, the warrant documents. There have been some reporting on it that hasn't quite been accurate, so I've sort of taken it upon myself to dig into the pleadings through the federal court filings myself, and just maybe make a post or two about it when things don't look like they're being reported accurately, or maybe the full story is not being told. They seem to have caught up, and I haven't really had to do a whole lot lately. People seem to sort of have their bearings on this case now. There was some sort of misinformation being given out in the beginning by all media outlets. Anyway, something caught my eye the other day, and I kind of laughed when I saw it, and I put it aside for later because I wanted to sort of catch my reaction to this and just sort of show you how I take a look at a new pleading and maybe just kind of walk through it. But there was a very curious filing from a guy named Raj Patel, and I just looked at the first page or two and was pretty amused at what he had filed, and I thought it would be fun to just kind of check it out together. So here we go. I'm going to go ahead and pull it up. Okay, so they filed it into the 81294 case. That is the case in which Donald Trump actually filed suit against the United States of America. And so there's two cases going on in parallel. One case is called, In re, the sealed search warrant, and the other case is Donald Trump versus the United States of America. So a gentleman named Raj K. Patel filed a motion for intervention and memorandum in support of granting the motion for intervention. He is pro se. That means he is by himself without a lawyer. He may be a lawyer. This Raj Patel is from Indianapolis, Indiana, Marion County. I actually went to law school in Indiana University at Bloomington, Indiana, very close to there. So he files this thing. He's got a nice table of contents, seems to be well organized, looks like it's a professional brief. He did demand a jury trial, which I thought was interesting. He filed this just about a week ago, August 25th. Raj's motion for intervention, memorandum supporting, yada yada, statement of facts, argument. He claims intervention of right and permissive intervention. There's two rules there. Demand for relief, certificate of interest, and certificate of services. Claims are asserted at page 10. So anyway, the movement respectfully moves the United States District Court to allow intervention either by right, I assume he means, or permissively. The present civil action contains a lawsuit against the United States to determine whether executive privilege was violated by a former president of the United States, Donald J. Trump. I am interested in becoming president of the United States and have a property right or interest of holding privilege protected by the United States Constitution, acts of Congress, along with all the honors and rights which come with the holding of the office of presidency, and is thenceforth omnipresent, powerful titles, styles, precedents of the honorable, the excellent, including after leaving office. Okay, so this guy wants to become president, has an interest in becoming president, therefore he has a property right or interest of holding a privilege for the office that he may have someday and he should have after leaving office. Now, I will say that it seems to be a colorable argument as to whether a former president can assert executive privilege over things that occurred while he was president after a time when he is no longer president, or whether the current sitting president has the sole and exclusive authority to claim or to waive the privilege. And really here the issue would be the waiver of the privilege, because Donald Trump could say he wants something protected by the presidential privilege, executive privilege. And of course, Biden could say, no, I want to waive that. I don't care if anybody finds out about this. Very unique argument here that someone who aspires to be president has an interest in asserting the executive privilege. So anyway, he cites to Federalist numbers 78 and 80, yada, 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 a few other things. Let's see. One, okay, he's going to give us a series of arguments, I guess. If a matter is decided against the President of the United States, I have a statutory protected right that will be violated, even if I am appointed by Electoral College President. The holding and consequential precedential value of this court's disposition of the action may, as a practical matter, will impair or impede my ability to protect my interests unless existing I adequately represent that interest. Two, in addition, I have a claim or defense that shares with the main action a common question of law or fact about executive privilege as intended by the framers. So he's saying he has similar interests that could be should be joined to this case, so the court doesn't have to duplicate efforts. Next, the court must allow intervention because the Federal Religious Freedom Restoration Act, RFRA, gives me an unconditional right to intervene and assert a claim or defense of the interest of holding the presidency, which is a religious right, as it is a political right too. Fascinating argument. He's citing Burwell versus Hobby Lobby, Justice Kennedy concurring. In our constitutional tradition, freedom means that all persons have the right to believe or strive to believe in a divine creator and a divine law. For those who choose this course, free exercise is essential in preserving their own dignity and in striving for a self-definition shaped by their religious precepts. Free exercise in this sense implicates more than just freedom of belief. It means, too, the right to express those beliefs and to establish one's religious or non-religious self-definition in the political, civic, and economic life of our larger community. And fourth, the court may allow intervention because the Federal Religious Freedom Restoration Act gives me a conditional right to intervene when my free exercise of religion is expected to be substantially burdened, I assume he meant. Okay, let's see. I haven't gone this far yet, but a pro se intervention, however inartfully pleaded, must be held to less stringent standards than formal pleadings drafted by lawyers. So he's asking the court, do him a little favor here, give him a little bit of a break because he's not a lawyer. So don't hold him to the same standards. Raj is a citizen of Indianapolis, Indiana. He was born in 1992. That means this fellow, September 2nd, tomorrow, this guy turns 30 years old. Happy birthday, Raj. From 29 to 10, he was student body president of the Brownsburg Community School Corporation. That's good for you. 2010, he attended Emory University from 2010 to 2010 in Atlanta and graduated with a bachelor's. So for 1 year, he attended college and got a bachelor's degree. Good for him. Okay, and he was cum laude in religion. That's great, and Bachelor of Arts in Political Science. An all-A average. 2013 to 14, SGA president of Emory University. Congratulations, in Atlanta, Georgia. I'm guessing this is just a typo up here. He probably was there from 2010 to 14. 2015 to 17, enrolled at University of Notre Dame Law School as a Juris Doctor candidate. I voluntary separation of leave in good standing in November of 2017. So that's 15 to 16, 16 to 17, and then the beginning of his third year of law school, he has a voluntary separation in good standing. So he has completed 2 complete years of law school. Law school is typically a 3-year program, although some people do, night school and do it in 4 years. But it looks like he came straight out of college into law school. He's got 2 years and about 2 months in before he leaves in November, in the fall of his third year. Most presidents of the United States have been lawyers, and the framers are read in the law as currently prepared by law schools. I've completed the minimum law school graduation credit hours as required by the American Bar Association, 68 credit hours, but not the University of Notre Dame's institutional, I know, Notre Dame, Notre Dame, whatever, requirement of 90 credit hours with 22 remaining credit hours not completed yet. I've been under the constant lawless use of a stress weapon. This is taking a turn. I have been under the constant lawless use of a stress weapon, which causes stress and physical and mental incapacitations and adversities. Oh, see also Patel versus United States, a 2004 case, affirmed in part and reversed in part, and a Federal Circuit 2022. I'm not. Maybe this is the year here. Maybe the case was originally filed in 2021, and it looks like at the Federal Circuit Court of Appeals in 2022 there was an appeal that was affirmed in part, reversed in part, and there's a pending cert petition. That means pending cert means he has applied. He's filed a petition for writ of certiorari asking the Supreme Court of the United States to review the case, and that is pending. Anyhow, I have a feeling we will find some gems in that pleading, find out what's going on with this guy, and I'm really curious to find out what the lawless use of a stress weapon is. Anyway, finalizing his background here, in addition to my styles and titles, through my heritage, by my blood and legal parents, I am top 1% of Americans in terms of income and cash on hand. Mr. Patel, congratulations on being in the 1%. That is, I would say, an accomplishment, but you do seem to be claiming it through your heritage and your blood and legal parents. So anyway, congratulations. Donald Trump, the plaintiff, is a Republican, and the main action states that he is the likely 2024 Republican National Committee's nominee. Very possible. He is a Democrat. I was the founder and vice chair of the Indiana High School Democrats. Good for him. Hinduism, an old religion from India. I have heard of Hinduism. Although I haven't seen this word before, Kshatriya religion. I apologize, don't mean to butcher that word and mean no offense. Despite the differences of political parties, my religion requires me to honor and respect the head of state and the fellow Kshatriya, a fellow statesperson in the Hindu ecclesiastical interpretation of the happenings under the Constitution. Following the norms and varna of this social group and caste wins the favor of Vishnu, God, possibly United States, showing distrust in future colored presidency or presidents who might not have white skin color in them. This complaint follows. Okay, not sure I'm following. Okay, intervention. This is his argument section here. So he's just laying out the background and maybe the legal posture. And now he's getting into his argument. Intervention may be timely filed even if it occurs after a case is concluded. That's an interesting precedent. I have no reason to doubt that case holds that. At the heart of this case, he's talking about intervention of right, the laws governing that. Act of Congress is not required to discharge privileges and immunities clauses. Okay. Motion is timely filed. Complaint initiated less than a week ago on August 22nd. Sure, he files this on August 23rd. It's going to be hard to say it's not timely. Raj Patel has a property interest in the constitutional clout of the privileges of former presidents of the United States. And movement Raj K. Patel has a political and religious interest in and from the transactions of the ongoing litigation. The decision of the main complaint will define and create an untenable precedent about presidential records and the use of vested shared powers between the incumbent president and former presidents, which affects, I think he means affects, AFF, movement Raj K. Patel's religious interest in supporting a former and current head of state, the presidency, and His Excellency's own interest in attaining and self-defining the presidency. Is he referring to himself as His Excellency here? I'm not sure I follow that. So let's try to break that down again. The decision on the main complaint will define and create an untenable precedent about presidential records. Um, so that's a really hard claim to make because he, of course, has no idea what the decision on the main complaint will be and whether the precedent set thereby will be tenable or untenable. So, maybe to give him the benefit of the doubt, and giving him credit for only being 68 out of 90 credits towards his law degree. Um, Maybe he's just saying that um, the decision on the main complaint may create an untenable precedent. Um, anyway, which affects his religious interest in supporting a former and current head of state. I don't really follow what he's trying to say there. Currently, the President Trump seeks a special master in accessing defendants' records. And here the defendant is the United States of America. And in fact, the United States of America is asserting, I believe, in filings filed in the last day or two and or in court today, they're asserting, hey, those are our records. These records belong to the United States. They don't belong to the president. And that's a little bit of a chicken and the egg question because I understand the Presidential Records Act, allows the president to decide which records will be, archived and which records will be, not presidential records to some extent. And I'm not picking sides here or saying I know who's right and what's what. But anyway, the government's making the point that you don't get to have a special master, protect your documents because they're not your documents; they're our documents. Again, a bit of a chicken or the egg question there. Oh, yeah, here we go. Currently, the President Trump seeks a special master in accessing defendants' records, but His Excellency Patel has an interest in making sure the record access accords with original intent. Original intent is capitalized. I'm assuming he's assessing some special meaning to those words, but he does call himself His Excellency Patel, which is kind of fun. Further, it is important that information sharing and restrictions are not fettered with against an incumbent and former president as movement's political party, like President's Trump political party, have determinately relied on the United States in letting the party and its presidential nominee victory and successors can make fair use of presidential records. Bro, I'm lost on that. I'm not even going to try to go back and comprehend that. Article 6, Section 1, referring to the Paris Peace Treaty, Mason, 1784, Committee of the Whole, the records of the Federal Convention, 1787. I'm sure there is lots of great reading to be had there. Don't have time right now. Therefore, movement Raj Patel has an intervention by right. Okay, so if you followed that, maybe you should be a federal judge. I didn't follow that, and I'm not sure I understand the therefore connection, that because of everything he said, he's got an intervention by right. But let's continue. Number three, existing party, Donald Trump, Republican, do not adequately represent movement Raj K. Patel's interests, Raj K. Patel, Democrat interests, as they have different succession interests or are from opposing political parties. Sure. While existing parties are not political rivals or are not expected to become political rival in 2024, especially as movement Raj K. Patel is not 35 years of age. The movement and the existing parties are of different religious traditions. President Trump has openly identified as Christian and has descendant from Christians, as has President Biden, who is Catholic. And movement Patel is Hindu and descendant of Hindus. Therefore, existing parties cannot adequately represent movement Mr. Patel's Hindu ecclesiastical interpretation of our happenings. Okay, so there's some religious political connection that he's trying to draw here, and I really don't understand it, and that's probably just because I don't understand. I'm not familiar with the Hindu ecclesiastical interpretation of anything. But in addition, the existing parties are ideologically different with different considerations and focuses, regardless of party affiliation and constitutionalism. But CF, that is like compare Patel versus the United States. That's the case he's got up on cert petition to the Supreme Court. Therefore, existing parties cannot adequately represent. Okay, so he's saying like he's different than them, his interest is different than them, and they're not already litigating all the same stuff for all the same reasons with all the same vigor. Next, defending the United States of America is interested. How long is this thing? This thing is 25 pages, and we are only like 7 pages in. So we're going to have to pick up the pace a little bit. Next, defending the United States of America is interested in preserving the institution of the presidency just as much as plaintiff President Trump and movement Patel, but defendant is represented by the United States Department of Justice, which answers not only to the current president, but also to Congress, and not the political parties or the general public or voting population in the United States Constitution, unlike plaintiff President Trump and movement Mr. Patel. Therefore, existing parties cannot adequately represent. Okay, fine. Government's not the same as Mr. Patel. Got it. Appointment of a special master will not sufficiently represent movement Mr. Patel's interest in the precedential effect of the venerable lineage of the main action. As it currently stands, the special mater will only address the Presidential Records Act as applied to President Trump and his records. Patel's common question of law is embedded and necessary to answer for the main action to be ruled in favor of President Trump. But unlike Patel, current parties assume complete constitutionality of the Presidential Records Act, and thus existing parties cannot adequately represent. Okay, fine. Permissive intervention. Yeah, we got a rule that permits permissive intervention. In exercising that discretion, yada, yada, yada. Boring. His motion is timely filed. Yeah, 3 days. Got it. His claim of defense, common question. He looks to be reiterating. Maybe. Main action have a common question of law about the constitutionality of the Presidential Records Act and its applicability. Okay. Patel raises his own constitutional law arguments, which will help this court adjudge the proposals made by President Trump. Trump raises other important constitutional questions of Fifth Amendment due process, fairness, and Fourth Amendment unlawful searches and seizures. Particularly, movement Mr. Patel to address the Privileges and Immunities Clause as applied to President Trump and other possible former presidents of the United States. Maybe he's talking about other possible future former presidents of the United States. Further, Amendment 1 and RFRA allows movement to assert this common claim or defense, yada, yada, yada. Therefore, Mr. Patel asks the court to allow permissive intervention. Good for you. Oh, Lord, this is kind of dense. Prejudice to the parties will not unduly prejudice the original parties because motion's timely, blah, blah, blah. Claims. All paragraphs above are incorporated in. Claim 1, Presidential Record Act is beyond Congress's vested powers. Okay, let's see what these got to say about this. Constitution Article 1, Section 1 allows Constitution, I'll see also Constitution Article 6, Section 1 referring to Mesa. June 4th Committee of the Whole, records, yada, yada, okay. Suits against other officials, including presidential aides, generally do not invoke separation of powers considerations to the same extent as suits against the president himself. Okay. Constitutional exemption for local officials. I'm just citing a bunch of case law I'm not going to look up. Not fair play when conscience-shocking behavior is so brutal and offensive that it does not comport with traditional ideas of fair play and decency. Okay. Breyer, dissenting from denial of cert, the physical security of an honorable has a special legal role to play in our constitutional system. Sure. But for privileges, there would be a loss of trust in enforcement. Privileges and immunities clause is why the American people have chosen to have a national constitutional government. Faithfulness to this clause defines the national character and the basis of the Union. Federalist number 80. This clause, which creates the totem pole of hierarchy of master, honors, and excellent, is not amenable per the Treaty of Paris of 1783 and administers sovereignty of the United States Constitution. Not following that. The citizens of each state shall be entitled to all privileges and immunities. Yep, got it. Constitutional hierarchy requires an exercise of executive power. No state shall make or enforce any law which shall abridge privileges. Okay. Act of Congress is not required to discharge. Got it. Congress has bound each district judge to administer justice without respect to persons. Federal government commands obedience to its laws to the Privileges and Immunities Clause. When enforcing privileges and immunities, the United States federal government has supremacy in protecting each citizen and need not involve state executives or other governments. Got it. Okay. I'm like really bored with claim one here. Overall, currently, THTHTE Joe Biden, the honorable, I'm lost there. I'm going to have to go back up to the top because I think I've seen those letters before. Joe Biden, the President of the United States, is the officer in charge of enforcing the Privileges and Immunities Clause. All right, so I'm going way back to the top. Did he do all that THTHTE stuff? Yeah, TETE, Raj Patel. I'm really confused by, yeah, ITETE, Raj K. Patel. Okay. Back down to page 13, claim number 2. Sorry for all the scrolling. Application of the Presidential Records Act is in violation of the Privileges and Immunities Clause. Equal protection, substantive. Okay, see claim 1. Got it. Former President of the United States can lawfully retain copies of presidential records from either his, her, their own administration or from another president's administrations under the vested powers of the president and the Privileges and Immunity Clause. Maybe. Well, Presidential Records Act makes information sharing with Congress and public a shared responsibility of the incumbent president and former presidents. Okay, can't say I read it, so I'm, can't pass judgment on that claim. As originally intended by the framers, there were no term limits. As originally intended by the framers, there were no term limits on the number of terms a natural-born American can serve as President of the United States. As amended by the United States, it seems that a person can be president for a maximum of 10 years. Yeah, I'm going to have to go back and look at that old Constitution again. I'm not sure I remember reading that before. The Lockean document, consistent with the powers vested through the Treaty of Paris 1983, made sure that previous presidents remained a part of the institution by allowing titles or other pensions. The framers, in addition to maintaining general welfare, formed the Constitution as contemporary plutocrats and to prevent unethical commercial conduct amongst factions divided into states. Framers loathed political parties as a way they challenged the state's role of maintaining the peace. However, from the very beginning of our current written constitutional experience, political parties have been inseparable and essential to statecraft. Interesting. The only link between the United States and political parties which prevent a political party from becoming the hegemon are the current and former presidents. The only link between the United States and the political parties which prevent a political party from becoming the hegemon are the current and former presidents. I got to be honest, I don't really know what a hegemon is. Can we look that word up? Substantive, masculine. Okay, that's. I don't. Nobody seems to know what this word means. Open in dictionary. Is dictionary going to give us hegemon? Substantive, masculine. Der hegemon. Yeah, sorry guys, I can't can't say I understand what hegemon is. Maybe he means hegemony. Is that a word? Did I make that up? Okay, hegemony, hegemony, hegemony means leadership or dominance, especially by one country or social group over others. Okay, so what he's saying is the only link between the United States and the political parties which prevents a political party from becoming dominant over governance are the current and former presidents, which honestly seems a little bit backwards. I think the presidents you're going to kind of conceive as the most powerful person of their political party at any given time. But allowing a former president access to records preserves and creates the checks and balances which are fundamental to our republic. Plausible argument there. While the incumbent president here, President Biden, can trigger broad probably, national security powers to determine who has what information, including among former presidents. Without such concerns, there is no constitutional permissive power to limit the former president from retaining copies of presidential records as long as they are securely kept. Sure. The framers deemed the text to be evolutionary for at least 3 reasons. It can be amended. I think that sort of militates against it being evolutionary because you can amend it if it stops meaning what you wanted it to mean. 2, it was a polemic calling on states to approve and ratify and change the state of slavery with what will be the force of the newly formed union. I don't know that I follow that either. And 3, it is intended to be passed down to the generations of the Union's civilization as stated in the preamble to the United States Constitution. Fine. While there was neither a king nor a noble house, framers who were young at the start of the call for independence, especially Madison and Yates, intended that the presidency would evolve, the presidency itself would evolve, because former presidents will raise their own kids to be better leaders than they were. Okay. Trump is not converted or aided in the conversion of United States documents to presidential documents. Former presidents need to be able to access records quickly and efficiently in their copies in order to preserve their considerations and executive agreements. I'm not sure I follow that either. The current action is inconsistent with the framers' elitist and aristocratic mindset accorded from the Constitutional Convention. Just wow, okay. The current happenings in the main action require me to intervene and exercise my political rights to protect the institution of the presidency, and so I am able to exercise the force of the presidency and further the United States Constitution, our social compact, as my religion requires me. All right, oh boy, don't look ahead to claim 5. I mean, come on. We're going to start with claim 4 here. Appointment of a special master will not be sufficient to address the claims and interests of which are a part of this intervention. The special master will access the disclosures of additional documents and affidavits. Okay. The special master will not address the constitutionality of the happenings of the case and the statute, the Presidential Records Act, which vests subject matter jurisdiction, and its constitutionality, which challenges the Privileges and Immunities Clause of the United States Constitution. I don't think that's a full sentence. Okay, it is unclear, claim 5, unclear who can enforce Presidential Records Act and its common law vestiges against the former president. Very limited body of federal common law, maybe, but okay. Anyway, can THTHTE Biden enforce the applied law to THTE Trump? Biden's got a whole lot of whoa, and then can THTHTE Biden enforce the applied law to THTHTHTHTE Obama? Um, Man, maybe someone out there can tell me what this THTE stuff means. But he's very consistent in applying them. He's not just randomly applying them. Biden's always got the same sequence. Reagan is a TETHTHTE Reagan, if Mr. Reagan was still alive. TE, oh, TE comes from the time when Reagan was student government president. TETHTHTHTE in parentheses. Of course, now we've got to distinguish between THs and TEs in parentheses and non-parentheses. But TETHTHTHTE Nixon, question mark. TE comes from the time when Nixon was student government president. So I'm guessing a TE has something to do with being president of something, of student government. Can THTE Trump, was Trump ever student government president? Can THTE Trump, one thing is clear, Trump has a lot less THs and TEs than everybody else here on this distinguished list. And he left out Bush and he left out Clinton from our, presidents of recent memory. Actually, both Bushes. Can THTE Trump enforce the applied law to THTHTE Biden? When does the United States Constitution allow for its authoritative veil to be pierced and allow the commander-in-chief to assert fiat to arrest and more authoritatively powerful former president? When does the United States Constitution allow for its authoritative veil to be pierced and allow the commander-in-chief to assert fiat to arrest more authoritatively powerful former president? So we got our commander-in-chief, our current president, and he's going to assert fiat, basically to say, I got the power, and arrest the more authoritatively powerful former president. I'm guessing saying he means more popular. The RFRA has been violated because, claim number 6, because the main action burdens my ability of self-definition as president of the United States. Oh, I guess we're identifying as president these days, maybe? Hinduism requires me to be the best elected official as possible and to support the Privileged Immunities Clause. Hinduism requires me to support both President Biden and President Trump as our head of state, but the law is the king here in the United States. A violation of the king, the law, would hinder my ability to president and former president of the United States. For instance, a change in the status quo of how President Trump allowed for records to be kept risks welcoming racism into how incumbent presidents might treat former presidents, or the racist effect a presidential holding can inspire in other governments and polities and the business world. Thus, I must assert this claim and find that President Trump's actions are protected by the United States. Okay, Privileges and Immunities Clause and substantive due process. Demand for relief. The excellent. Ooh, maybe that's what TE means. The excellent Raj K. Patel, with the interest, further decency within our nation and upholding our Constitution, asks this United States District Court for the Southern District of Florida to grant either all or some of the following relief: allow an intervention, relief described in the claims section above, find unconstitutionality of the Presidential Records Act, other remedies which the court might deem fit. And actually that might sound kind of dumb, but actually it's kind of required, and it's in pretty much every pleading. Signed, the excellent Raj K. Patel. Okay, so the T's, TH's, this would be like the honorable, the excellent Biden, etc. Okay, demand for relief. Oh, and then we've got a certificate of interest, which is the last few pages, and then we have got to go here. I, the excellent Raj K. Patel, pro se, am appearing without counsel, giving full faith as yada yada. I've completed 5 of the 6 semesters of my Juris Doctor candidacy at University of Notre Dame. I'm going to say that if he left in November of 2017, I don't think he really completed 5 semesters. I think he participated in 5 semesters, but I just don't think you finish a semester of law school in November. Anybody who's going to University of Notre Dame Law School, please let me know. And there again, he says where he was enrolled from August 2015 through November 2017. He's completed 68 out of 90 credit hours, leaving 34 the first year, 34 the second year. I'm not sure how the math breaks down there. That's a lot of credit hours in 2 years, but maybe it's possible. Such I've completed the minimum number of credit hours required by the accrediting American Bar Association to allow a law school to accredit me a Juris Doctor degree. Amongst the grades in my Juris Doctor academic courses I received at Notre Dame, received an A minus / A in contracts, A minus A in civil procedure, BA in constitutional law. While under Weapon S. In the summer of 2016, I worked as summer associate in the City of Atlanta Law Department, Atlanta, Georgia. That's good. In the summer of 2017, I worked as a summer associate at Barnes and Thornburg in Indianapolis, Indiana. And there's some people who went there. And I hold a Bachelor of Arts in Poli-Sci Cum Laude in religion from Emory University in Atlanta, and I attended both Oxford College and Emory College. Graduated in 2014, 3.718 GPA with no pass-fail grades. That's pretty good. Emory is a top 20, top 25 U.S. News Tier 1 Best National School. Notre Dame ranked in top 25 best law schools in the United States. No reason to doubt that. Certainly accomplished in his undergraduate endeavors. I was student body president of Brownsburg Community School Corp. 2009-2010, good for him. Student body president, maybe that's where he was the excellent, because he was student body president twice. I was also the Notre Dame Law School Student Bar Association rep to the Indiana State Bar Association from September 2017 to November 2017, a long and illustrious 2-month engagement. All jurisdictions are local and with an international constituency. Okay. Each time I was elected student body president, I attained thenceforth omnipresent styles, the excellent, for each election, which are protected by both the Privileges and Immunities Clause and Privileges or Immunities Clause of the United States Constitution. See generally Federalist 80 and Prince versus United States, quoting Principality of Monaco versus Mississippi. I've not received legal advice or counsel from anyone else for this case. That I do believe. Okay, so each time he gets elected student body president, he attains omnipresent styles of the excellence. So that is correct. I have been president of a thing or two in my life as well, so I probably need to go ahead and revise my letterhead and my pleadings templates to reflect my styles of the excellency. Certificate of service, he's serving, I guess these are Trump's lawyers. I'm not sure if for PLLC, maybe that's, yeah, I guess those are all Trump's lawyers. I don't think the government had appeared in the case at that point. And he's proposing an order which is ordinary and permissible. Certificate of service is saying he sent it to everybody. Here's a little cover page information sheet. Um, and that is that, guys. I I think that kind of drug on a little longer. It got a little boring, very interesting, um, and certainly, a the excellent Mr. Patel is a very smart individual. Although I do think, honestly, had a bit of a hard time stringing together some coherent arguments there. As for intervention, I think basically his main claim is that he is a person who is interested in becoming president at some day and therefore has a property right or a legal interest in the nature, claims, result of this pending court action. Don't think it's going to fly. I think his motion to intervene is going to be denied fairly summarily, and but I'm sure that Mr. Patel will not go down without a fight, and he will, in all likelihood, appeal to the Court of Appeals, whatever circuit Florida is in, and probably petition for cert to the United States Supreme Court. Perhaps in a future video, if anyone is interested, I will find out what this unlawful use of a what weapon, special weapon, stress weapon. I will find out. I'll commit to digging into that case. Not necessarily going to be a 30-minute video, but we are going to check into that and see what's going on. Thank y'all. Hope you have a great day. Peace out.